Good afternoon. I call this meeting to order at 2:02 p.m. Welcome back, everybody. I thought we would meet every Monday here for the month of December, so clear your calendar next week. I'm joking. I really hope that's not necessary. Here for a meeting to discuss the issue of recounts of proposals 2022-2 and 2022-3. The meeting was noticed, and Jonathan, any comment on it being properly noticed? Anything to add to what was put out there publicly?
No, just that it was published in accordance with the Open Meetings Act.
Okay. Thank you, sir. As such, what we have before us in terms of an agenda, number one will be public comment. Number two will be the consideration of the meeting minutes for the November 28th, 2022 meeting. Number three, consideration of the procedures and interested parties for the partial recount of proposals 2022-2 and -3. And number four, all other business as presented to the board. We have a much shorter stack of public comment than what we had at the previous meeting. So I am going to, at chair discretion, leave that at the front and ask that people who have submitted to speak as public comment that are not petitioning to be an interested party to come up and speak. Again, as I've reiterated numerous times throughout these process, please be respectful of others who are speaking. I think in looking at this crowd, they don't have as much to worry about maybe as we did the week previous, just with lesser number of people. And ask that you do keep it to your minute. I will be pretty lenient and giving you a little bit of time to wrap up, but you know, it was noticed for a minute, so make sure that you keep it within that. That being said, anything, Mr. Brader, you would like to add before we do public comment?
No, we have one, I think, one accommodation, Zoom public comment. So,
okay.
Yeah.
And so with that, we'll kick it off with public comment, and we do have Mr. James Gallant on Zoom or video link, so if tech wizards could get him up and going, we'll let him speak for an hour, or a minute. 1 minute. If somebody is able to keep track of that, that would be great. All right, so he did. Okay. Well, until we get him back on, why don't we start with those who are here in person. And the first one I have on my list is Michelle Haroon. And after Michelle is Trish Oliver. And again, for comment, please state and spell your name so our reporter can get that recorded properly. And because you are not testifying per se in one of these items, there's no need to swear you in, and it looks like your microphone is on, so
okay.
Go ahead, the floor is yours.
Thank you. I'm Michelle Haroon. The last name is Haroon, Haroon, and my first name is Michelle with 1 L. I'm a CPA here in Michigan. I have an audit career that includes IT audit and financial audit with even Big Four firms. And I wanted to remind this group about Jocelyn Benson's 5 violations in front of the court on various election type matters. To specify, those include number 1, Ganetsky versus Benson. That was about the signature verification relaxation per the Administrative Procedures Act. Number 2, the Kara case about the 6-foot rule between poll challengers and their workers, the workers on the elections. The Johnson case, number 3, which was about ballot acceptance after 8 p.m. on election day. Number 4, which was the O'Halloran case, and that was about the poll challenger manual infringing upon the rights of poll challengers. And number 5 was the Davis case, which was about restriction of open carry rights at the polls. Because of the above, I mean, I think a transparent partial recount of proposals 2 and 3 is essential. Proposal 2 especially, I mean, that takes a lot of the rights away from the people to even call for an audit, you know, if something else happens in the future. And in addition,
Michelle, hate to interrupt, but again, your minute's up, so if you could wrap it up in the next 10
Sure.
seconds here.
Okay, in addition, a full forensic audit and investigation is needed for the November 8 election. Thank you.
Thank you. Still working on Mr. Gallant, or?
Oh, can you hear me now?
Yes. Mr. Gallant, we can hear you. Please do state and spell your name for the record, and then your time will begin. 1 minute, please.
Okay, James Gallant, Gallant, James, Marquette, Michigan. Are we good?
Yep, please continue.
Okay. Well, it appears that both the Democratic and Republican parties of Michigan are taking advantage of the people of the state of Michigan through this Board of State Canvassers. And I'll be pursuing a complaint through Lara to get both of their nonprofit statuses revoked for violating their stated purposes. Both the Ingham County and the Marquette County canvassing boards, I witnessed them voting with only 3 members, which is a majority of one of the parties, which is in direct violation of Article 2, Section 7 of the Constitution. Robert's Rules of Order, page 366, line 8, states that there shall be no debate before there is a motion that is properly seconded. And now it's like you did not approve the agenda today. I see that there's no vote on the public comment time, and it appears that the Director of Elections has unilaterally changed the rules on the fly. No voting, no objections by unanimous consent. Just changed it on the fly. But without having Robert's Rules of Order as your parliamentary authority manual, you don't have any rules to suspend the rules or unanimous consent or any of that stuff. And it does not appear in those rules that you state that you have.
Thank you, Mr. Gallant. Appreciate that.
Please.
Okay. Next, we have Trish Oliver, and after Trish is Nomi. And I don't want to single anyone specifically out right now, but if you're going to have sidebar conversations, especially if they're audible up all the way up here, ask that you please take them outside the room. Need you to, there you go. Mike, it's on now, go ahead.
Hello, my name is Trish Oliver, Trisholiver. I'm here today to call to attention the misleading advertising around the proposal language. Secretary of State Jocelyn Benson was supposed to send the correct full language to the counties, and then they were supposed to send it to the precincts 60 days before the election. Jocelyn Benson never complied, never did that. And in addition, the full language of the proposals were supposed to be posted in every precinct. And in addition, the absentee ballot recipients were supposed to receive the full language. All that was made available to them on the proposal was 100 words, which was misleading, so that people were not fully informed as to what the proposals pertain to and what they were voting for. So again, this is another one of Benson's violations and should be considered. Thank you.
Thank you, Trish. Hello.
Hello.
You know the drill.
I do. I'm Nomi Joyrich, Nomi Joyrich, and I'm the Director of Jews for a Secular Democracy. As a person of faith and a representative of 2 faith-based nonpartisan organizations, I understand the need to protect the wall between religion and government. This wall protects our right to religious freedom without government interference, and it also protects the government from religion. The rising voices and dangerous cries of Christian nationalism have no role in our government and should not be able to impact our election process. I am proud to live in Michigan where we have safe and secure elections. I'm a volunteer manager of the Voter Protection Hotline, and this year I was impressed with how smoothly everything ran. A recount is unnecessary and a waste of taxpayer money. I know that an extremist from Florida will be paying for some of this, but the taxpayers are left to pay for the remainder of the tab. Not only is it mathematically impossible for the recount to change the outcome, it also will not address any of the unfounded claims in the recount petition. Please do not indulge baseless accusations or the efforts to breach the wall separating religion and government. Thank you, and thank you to everyone on this board for, I know it's hard work.
Thank you much. Up next, Elizabeth Buckner, and after Elizabeth will be Shirley Schaefer.
Elizabeth, Elizabeth, Buckner, Buckner, and I'm going to reiterate some of what Nomi just said. I was an election challenger for the first time in my life. I'm 72 years old, and I was absolutely amazed at how smoothly the election went. I got to know people that were Democrats, that were poll workers, and people that I would consider far right. And everyone was professional. They did their job. I had absolutely nothing to challenge because when an issue came up, they handled it properly. I think this whole thing is frivolous and it's a waste of money. It's going to cost taxpayers money. There's so many people that could use that money more so than trying to challenge this, which is not going to change anything. Thank you.
Thank you very much. Shirley Schaefer. And then the last one I have for public comment is Holly DeBoer.
Hi, I'm Shirley Schaefer, and I represent the Tuscola County Republican Party as treasurer.
Can you spell your name for
yes. SHIRLEYSCHAEFER.
Okay.
And I want to thank you. I want to thank you for allowing us to recount. I am a poll challenger. I was not able to observe the final bagging of the ballots in Vassar Township, a place that's probably not even in your mind on the map. But for the most part, I was kicked out and made to leave. I have an 8-page challenger report of violations of election law. And like I said, that's not even on the recount list that I obtained. So I want to thank you for giving us the opportunity as the people to do this recount. And we, the people, did serve notice on you last time. I have additional notices here, and I also have the definition of canvass, which is the act of examining and counting the returns of votes cast at a public election. And I also have the definition of certify, to officially confirm that something is authentic. So with that said, I want to add to the notices that were submitted on last Monday. Thank you very much.
Thank you. Give one to her, and then she'll pass them to the rest of us. Last on public comment, sir. Yep. Go ahead and bring it on up to our reporter here, and we'll have you go after Holly. Are you Holly? Yes. All right, coming up.
My name is Holly DeBoer, HOLLY. DEBOER. I was looking at the list of the counties and the precincts that are going to be considered for a recount on Proposal 3, and I'm here to ask permission that Precinct 5 of Ada Township be considered for that partial recount on Proposal 3. During voting, Precinct 5 of Ada, Michigan, while the voters were standing in line for 40-plus minutes, they ran out of ballots. The precinct came out and asked the people to go home and come back in an hour. And we all know what that means, that a lot of those voters probably did not come back. So I would like to see that Ada Township in Ada, Michigan, Precinct 5 be considered as one of the counties or one of the precincts that be considered for the recount, the partial recount on Proposal 3. Thank you.
Thank you. I assume when we get into the issue of the consideration of the procedures that you'll address items like that of, you know, how they determine which precincts, which areas will be included in this?
Yeah, I can explain that.
Okay, thank you. Last public comment we have is Scott Offney. Apologize if I've got that wrong.
No apology, you can call me whatever you want. I'm not offended.
Let's see what you have to say first.
My name is Ogney, but you can call me Ogney, you can call me Scott, you can call me ugly. I don't take offense to it.
All right.
All right, my name is Scott Ogney. I'm from Jackson, Michigan. I am an independent.
Spell your name.
Ogney, A-U-G-H, N as in Nancy, E-Y.
Okay.
I'm an independent election investigator based in Jackson, Michigan. My expertise is with relational databases, specifically how data connects to each other. And I am 100% supportive of this oversight action in terms of recount, because I can tell you, as somebody who's been investigating this data for 15 months, the end data, what the Bureau of Elections is giving the public, does not match up to what the clerks see. And I can tell you, I have evidence that the Bureau of Elections is operating two separate databases, one the public sees and one the clerks, both the county clerks and the jurisdictional clerks see. I am more than happy to open and present evidence to this committee at any future time. I am going to be working in Jackson County on this recount process, and I'm going to take notes. I have not worked as a poll worker in the past, but I know enough about the evidence and the data to know that this is imperative that we continue to follow through with this. Thank you very much for your time.
Scott, if I may, I'm noticing when I look at this, I misread, you checked yes for petitioning to be an interested party, meaning to participate in the recount process.
Yes, I'm associated with Election Integrity Force.
So you are petitioning to be considered an interested party?
I'm not sure what that question was pertaining in terms of the recount process. Okay. I'm not sure I understand your question. Are you saying that each individual involved with this has to apply separately?
Director Brader will get into that when we discuss these items, but that is my individuals or groups that wanted to be considered for this needed to send notice by 4 p.m. Friday.
Or they can do it today.
And they can do it today in person. And so if you are here to do that in person, I just want to make sure I'm considering that.
Are you saying everybody else in the rest of the state needs to do the same thing?
If you as an individual or a group that you would be representing or working with did not provide that appropriate paperwork, then it is not within our purview to consider you as an interested party.
Correct me if I'm wrong, but Election Integrity Force is the one that's funding this.
So, Director Brader, in terms of the people funding this?
I think item 3 is for the board to consider the procedures and interested parties, so I think we can discuss it on number.
That's what I was thinking, and that's
procedures, why please forgive me, sir, but procedures, there are a lot of procedures that have not been outlined thus far in terms of security.
And that's what we're here to do today.
Right, the transfer of ballots from one place to another. That has to be addressed, Mr. Brader. Any other questions for me, sir?
No, so okay. You would like to participate in the conversation?
Yes, I do.
Okay, thank you.
All right, thank you.
Not seeing any other sheets, any other individuals. That will conclude the public comment portion. As such, we'll move on to item agenda number 2, which would be the consideration of the meeting minutes for the November 28, 2022 meeting. Any comments from my fellow board members on this? Any comments from staff? Anyone down there? Pretty self-explanatory, right?
I move that we adopt the minutes of the meeting of November 28, 2022.
I'll second that.
Okay, we have a motion and support. All those in favor of the motion signify by saying aye. Aye. Any opposed? Motion carries 3-0. All right, agenda item number 3. The consideration of the procedures and interested parties for the partial recount of proposals 2022-2 and 2022-3. and that's obviously what we're all here for today. You'll forgive, at least myself, I can't speak for the other board members, but this is certainly unprecedented in anything I've done on this board, so figuring out what these processes are and how to handle this. Ask for your patience as we move through this. We want to be transparent. We want to make sure that everybody's voice is heard. And I have one question that arises, and then I'll hand it over to Director Brader to give us the read-through of why we're here, what we're looking at doing, what the board's role is. I see on our minutes that one of the motions we approved was authorizing the Bureau of Elections to represent the board in any recount of votes cast at the November 8, 2022 general election. So some people may be wondering, why are we here if we've already provided authorization for staff to do this? Floor is yours, sir.
Sure. I will take it from there, Chair Don. So this is a request for recount for ballot propositions, which is governed by a separate section of the law than governs recounts of races between candidates. So typically when we request that authorization from the board, it's with the idea that if there is a recount requested by a candidate, we will conduct that recount on behalf of the board under the board's supervision using the standard procedures that we use with county boards of canvassers. In this case, an elector of the state has requested recounts of 2 ballot propositions. So there is a specific section of the law, Section 880, that requires the board to meet and to approve, 880A requires the board to meet on the 7th day following certification, which is today, and determine procedures as well as the interested parties who will be able to serve as challengers during that recount. So in this case, Jerome Allen has requested partial recounts of 2 ballot propositions. For Proposal 2, he is requesting 47 precincts and counting boards be recounted. And to the prior point, the reason that these precincts that were included in the recount list are because those are the ones that he requested. So 47 precincts in Proposal 2. The statewide margin for Proposal 2 was that it passed by about 861,000 votes. In the precincts that have been requested under our analysis, there's a total of about 38,000 yes votes. So even if all of those were no, it would still pass. But those are the precincts that he requested. So that's what's under consideration today. Also with Proposal 3, in that case, he requested 909 precincts and counting boards. For Proposal 3, the statewide margin was about 583,000, and the total number of yes votes in those 909 precincts he requested are about 479,000. So again, even if all of those were no's, it wouldn't change the outcome, but those again are the precincts he requested, so that's what's being presented before the board. And so with that, under 880A, the board does have to determine the procedures and interested parties for this recount. We propose to use the same procedures that we use for other recounts, aside from the fact that in this case we won't have candidates, we'll have interested parties. And then we have several individuals who have requested to be considered as interested parties, and I think you have a few of them planning to speak to you.
So having participated in candidate recounts in the past, my recollection is each candidate assembles a team of volunteers, and they basically sit at a table with volunteer from the other side and witness the counting of the ballots. If you have a challenge or a question, you do it then at that table, and then it takes the agreement of all at the table essentially to move forward with the decision from the election workers. In this instance where we have, I'm just thumbing through some of the paperwork I have here, Election Integrity Fund and Force, Michigan Conservative Coalition, Michigan Democratic Party, Reproductive Freedom for All, et cetera. There's obviously more than 2. How would that play out in terms of, would this just be a larger table and all of these groups would have somebody at the table? Or would it be up to the groups to determine who they put at each table? Like they all kind of, you know, if 3 groups are on the side of recount, 3 are on no recount, do they just decide, okay, we're gonna divvy you up and you go to this precinct? Sorry, that's kind of a rambling question, but how does that work?
Yeah, so admittedly, we haven't had a statewide level recount of a ballot proposal where there might be multiple interested parties. But I believe that's what they would have to do. If there were more than 2 interested parties, then you would have to have challengers representing each one that were able to make challenges at each precinct that's being recounted.
So, and if they're applying for this interested party status on behalf of a group, then it's up to the group to determine how many people they field to do this. If they want to get 20 people and decide they're going to go to 20 set precincts they're concerned about, or they can recruit 500 people and send one to every. Understanding that correctly in terms of their rights in the process here?
I think that's correct, subject to the limitation that you can only have 2 challengers at each precinct and only 1 can be acting to make challenges at any given time.
Are you saying that you can only have 2 from each of the interested parties?
Correct.
Okay. At a particular precinct, which is being recounted.
So I apologize for my daftness here, not deafness. So if there are 6 groups, that could mean 12 people? Or that 6 groups on each side, that could mean 12 people, or still just 2 people?
If there were 6 interested parties, that could mean 12 people.
Okay, thank you.
Chairman Don, may I be recognized as Mr. Allen's attorney?
I've got a process for how we're going to do this, so I'll call you up when it's time. Well, board members, how would we like to proceed on this? I have before me some paperwork that was provided. It was a stack of paperwork delivered by Mr. Hartman. I do. Yeah, and it appears as though this is related to interested party request. Given that and some of the confusion on this paperwork, I will go ahead and call you up here to answer for specifically what this is and what you're attempting here. And I guess the initial question, in light of the request that this be provided by 4 p.m. or today, so again, I'm not criticizing, but given the supposed interest from this individual and the group you're representing, why did they not provide this in a clear-cut fashion, aside from just dropping paper on our desk on, 2:15 p.m. today?
Well, thank you, sir, for that. First of all, I would indicate that
Mr. Hartman, if you could state and spell your name.
Sure. Daniel J. Hartman, P52632, the attorney for Jerry Allen on behalf of EIF. In response directly to your question, Chairman Don, Mr. Allen understood he had standing as the person who filed the petition and put the money up. The other groups are, as an effort, because of the expedited timeline, various groups have reached out. It is not the intent to have all of those groups at every precinct, but basically, as I understand it, there are 47 counties, and the 47 counties will be running from their county board of canvassers under the law, will be running the recounts in their counties following the procedures that you set forward. So at each of those county board of canvassers, the board of canvassers for the county will then determine who the interested parties are at that county level to participate. It's not likely that each of those interested parties are going to be at every precinct. For example, MC4I, Michigan Center for Election Integrity, is planning to deal with like Oakland and Wayne County, whereas EIF is doing some of the outlying regions. So in answer to the earlier question and the concern, will there be 12 people at the table, these groups are trying to organize so that they have somebody representing the interests at each of the county boards of canvassers, but not having to necessarily have somebody at every single board. So I wanted to give you that clarity. So the reason that these papers came in is because they were literally handed to me. I'm substituting for the attorney that actually filed this, Ms. Lampert. She had a family medical emergency, so I was asked to be here today to represent Mr. Allen's interest as the petitioner. And that was directly to that point. And related to the procedure, I just wanted to offer that information so that you had the information, because you had asked some good questions about who would be challenging at the precinct level.
Okay. And member,
I just have a question listening to what you were just saying. Am I understanding that you have a whole bunch of organizations that all want to be involved, and this is kind of a, what your petition is today is a wild card? It's kind of a, everybody's going to be on proxy?
No. What generally is, it's not like that. We have identified somebody who's going to be a lead at each of the different counties and the Board of Canvassers. So the problem is that between last Wednesday when this petition was filed and Friday when you guys set the initial deadline through today, these groups were still being informed that Mr. Allen had filed the petition. They were getting together and trying to make sure there wasn't duplicative efforts, but everybody's interest in their community or their organization as a grassroots would be able to go and watch the recounts in their areas that they were interested in. And so what I'm suggesting is it's not really a wild card. It's taken, since Mr. Allen put up the money, and he actually put up probably 3 times of what was required to initiate this partial recount. He and EIF have been working diligently with all the other organizations to make sure that there would be observers present at all of these recounts.
Is there a list of all the organizations?
and so that's, thank you for bringing that up.
Oh,
Nice
sorry.
transition. What I have in the stack that you provided me is there's a Robin Peak with Republican Women's Federation, which I don't know if this is like some kind of ironic joke, but the font is just an absolute disaster on this, and it's all jammed together, and I'm having legitimate trouble making this out.
It's not a joke, but unfortunately, like I said, trying to get the information to you in the best form that I could. So please take that seriously, because that is a legitimate organization.
So the Republican Women's Federation is
Correct.
one. Michigan Conservative Coalition is another.
Correct.
And then I have 2 each, but I'm assuming you're being kind and giving us duplicates.
Well, actually.
Or that it's one for each.
Correct.
And that's Jerome J. Allen Election Integrity Fund and Force.
Correct.
So that's 3. Philip O'Halloran, Michigan Citizens for Election Integrity.
Correct.
And then Lori Skibo, Michigan Citizens for Election Integrity.
Yes, those would be duplicate. It's the same organization twice.
So 1, 2, 3, 4, 5, right?
Yes.
You presented 5 groups that wish to be considered.
As petitioners, as interested parties, I apologize.
And so I think Member Gurwitz has a question, but one thing I just want to get to as part of my question, I think what we all want to avoid is a situation where there are 3, 6, 10, 15 groups at these recounts and it's mayhem.
Right.
And people are not being respectful of the process. They are creating problems for local election staff to conduct the recount. I don't envision that's your intention with this, and I think if I am assuming correctly from a standpoint of our authority as the board, if we wanted to lay out kind of what you've stated and what I was alluding to of, okay, 5 groups can be part of this, but you assign one person to a table.
So I would make the following proposal, and the following proposal would be that at the time the County Board of Canvassers is conducting this, that the parties that are interested in the recount would be identified, and the Board of County Canvassers would identify whether they wish to have a spokesperson for, because there may be different interests. There may be some people that are in favor of the proposal. There may be some people opposed to the proposal. And I think a yes and a no vote organization should be allowed to participate and observe, and can speak for the group. But I do think that you don't have to, and I don't mean this in a condescending form, I don't think you have to manage that decision. I mean, I believe that the Board of County Canvassers can establish some of their procedures as they conduct this recount.
Okay. Member Gurwitz?
Right, I thought that I heard you say that you anticipated that the Board of County Canvassers would be determining who the interested parties are who would be able to participate. And you just said that again, isn't that correct?
Well, I think you should identify who the interested parties are, but as far as the procedure during the actual County Board of Canvassers, whether there's 5 people there and one is going to speak, or if the county wishes to have all 5 have the ability to speak, I think that the 47 county boards of canvassers should be free to make that determination, as long as they run it orderly.
You know, I assume, Mr. Hartman, that you have looked at the statute, which says that it is the State Board of Canvassers which makes the determination of who will be authorized to participate as interested parties.
Correct.
Not the county boards of canvassers.
I understand you get to anoint or not recognize them as interested parties, but once they are there as interested parties, I believe that they will be able to informally work out how the objections will be filed and how they'll be processed. And the Board of County Canvassers, because there's 47 boards and there's a short window, it's going to require that the Board of Canvassers, from the county perspective, keep an orderly meeting running. And I think you can authorize them to recognize that these people are legitimate. If one of these 5 people show up, then there should be somebody that has the view and the perspective. Now, in an ideal world, if there was 2 people from that list of 5 organizations present, and the County Board of Canvassers has the ability for them both to observe, they should be permitted to both observe and to fulfill their duties under the statute. But it will also be accommodated according to, in my humble opinion, according to the size, complexity, but the reality is not every precinct's even going to have an interested party likely at it.
Director Brader, from your standpoint or experience, again, reiterating that what we are determining here is unprecedented, at least in recent time, is what Mr. Hartman's saying at all correct or possible at the local level once we've made this determination? Because I am legitimately concerned about at least 1 or 2 of these, if not more, devolving into a circus, and that's not at all what I want to be party to, and I don't think the rest of my fellow board members do either.
Well, in the context of candidate recounts, which is typically what we do, this is not a scenario that we typically encounter. I mean, you could have more than 2 candidates, but you're not likely to have a very high number. I do think that from the perspective of the orderly management of the recount, it would be logical to, at each location, provide for a system in which at least one challenger who is for and against the proposal are able to observe at all times. And I do think it would be sensible as a part of the procedures, if there will be an excess number of interested parties on either side that would otherwise create the potential for disorganization, I'll just say, to provide the boards with the ability to manage them in that way. But typically, just frankly, we haven't, at least as far as I know, had a situation where there really were more than 2 or 3 sort of interested candidates where you would encounter this problem.
Yeah, Mr. Hartman, are you here representing Mr. Allen or the Election Integrity Force? Which entity?
Mr. Allen is is part of the Election Integrity Force, so I'm here. He filed it because an individual elector needs to file it under the statute to trigger it, but I'm also representing his organization. I was asked to submit the petitions on behalf of the other interested parties that are cooperating with Mr. Allen as an individual elector to execute the observation of the recount.
So those entities which you have identified here, you would expect them to be cooperating with Mr. Allen in the various precincts where the recount is being conducted. Is that correct?
Yes, I believe most, if not all of them, are already poll challengers that have been recognized in their various precincts. And so they're not, they don't have a reach across all areas of the 47 counties. So some of those organizations will only be interested in 1 or 2 counties.
Right.
So
Well, they don't have
yeah.
any status as challengers. Whatever they have been in
no,
the
I understand.
past, they would be identified by us,
Right.
the entity, which we recognize would have challengers.
What I was suggesting is that their former status as a challenger would give them some familiarity with the clerks and the election workers, and they've all part of the respect and decorum of an orderly process. But in answer to your question, I do believe that the way Mr. Brader just stated it would be a workable solution for the entities that Mr. Allen has asked to assist him in his elector-filed recount. That one person would, from the group, would be able to observe at all time unless the county board felt it was orderly that more than one could do that.
So if we recognize Mr. Allen, who is the petitioner in each of these,
Right.
as an interested party, then it would be reasonable for us to expect that he would coordinate the efforts of the other entities whose names you've given us. But they would not need to be separately recognized as interested parties. They would be acting pursuant to the direction of Mr. Allen. Am I correct?
They're all independent organizations of voter interest groups, and I don't want to disenfranchise any of them. I would also ask that it be uniformly applied, because I know that there are going to be proponents who have filed on behalf of both petitions as ballot candidates who have probably indicated an interested party status here today. And there may be a party, a Republican or Democrat party. I don't know what is in your list. So I think the way Mr. Brader stated it, that as long as there's one person that's for and one person against that's present, that would be the preferred method, that they would amongst themselves decide which one is going to be the one that is there. Mr. Allen doesn't speak for all those other organizations, but he also doesn't have the means to be at every recount.
Personally, I do not see how we could authorize 6 different entities to be interested parties, because that means that any of them would be able, any of the ones that you've identified, would be able to participate at any of the precincts. To ask the petitioner who has sought these recounts to coordinate some kind of observer status for the people that he expects to be there, it's certainly reasonable.
Right, and I'm not opposed to that, except I thought that should be coordinated by the County Board of Canvassers rather than Mr. Allen.
He's the petitioner, let him do it. And I don't think it is reasonable at all to expect the this state board of canvassers to authorize 6 different entities to be there for Mr. Allen.
All right, so just to be clear here, and let's work through this just real quick. If Mr. Allen were to, for each county, identify from this list who is authorized, would he do that in a form of a nomination, appointment, or how would you presume he would do that?
I would say that if Mr. Allen, that at any particular precinct, there is, if you looked at the procedures which are going to be adopted, the person who comes in as an interested party needs to sign in. So somebody needs to sign in for Mr. Allen.
Okay.
And I was just going to say
So you're going to limit the other organizations that aren't affiliated with Mr. Allen that may be opposing the recount, or who would have voted yes on the proposal, to one group as well? Then?
What I would think would be helpful is, given that there are 4 groups who have petitioned for interested party status on the other side of you, to see what they envisioned in terms of their involvement, because again, that's the same issue for me, is multiple groups. I think there could be some arrangement where there's a pool of people who are in favor of these proposals and a pool of people who are opposed, and they work together under an umbrella to arrange an observer and participate. but I think we need buy-in from both sides on that. And so I want to bring those gentlemen up, but I know Member Hauskamp had a question before I dismissed.
I just have a really easy question for you. You've got great groups here. You've got 5 groups that are represented in these papers. My question is each of these groups a formally, legally established entity in Michigan?
Yes, I believe so.
That's a yes or no question.
To the best of my knowledge, I know that EIF is, I know that MC4I is, I know that Michigan Conservative Coalition is. I had not heard of the Republican Federation of Women previously, but I haven't checked the documents, sir, so realistically speaking, if we, it sounds like Mr. Don is adopting a version of what Mr. Brader has indicated, but he wants to give the other side time to comment on that. That is the way I kind of envision it. I think you guys have restated it very similarly, that the yeses and the nos would have one person that they would collectively ask the Board of County Canvassers to recognize. The Board of County Canvassers felt that they could have 2 without disrupting the procedures. I think they should have the freedom to allow that to happen. But that's the way I envision it, sir, to try and make it orderly. You know, so the task of trying to get people that are interested in the outcome of the selection to be able to come there and observe the recount process where the chips may fall however they may fall, and to make sure that you had to reach out to different grassroots organizations that have voiced a concern, and we want to cooperate with you in making it an orderly process. And so I think as long as one yes and one no is represented at a minimum, if there are present, would suffice. But I don't speak on behalf of the other side, so.
Thank you, sir. If we have other questions, we'll call you back up.
Thank you, sir.
Make it quick.
Yeah, just an agenda item. Because of the way the recount was calculated and the money that was paid, would like to address that before the end of the day, if you would, sir.
I have here forms from 3 attorneys, each representing a different group that were supportive of the ballot initiative, and they are here to speak. I've got them in the order that they were handed to me. If the 3 of you would like to go in a specific order, you are welcome to do that, but the first one I have is Mr. Brewer, then Mr. Trebilcock, then Mr. Liedl. And you're going to be waiting a long time, Chris.
No respect.
Mr. Brewer, you are an attorney licensed to practice law in the state of Michigan.
Yes, Mr. Chairman.
Okay, and I'm sure she knows, but can you please spell your name?
My name is Mark, M-A-R-K, Brewer, B-R-E-W-E-R, with the law firm of Goodman Acker. I am the general counsel for the organization known as Promote the Vote, which is distinct from the ballot question committee, which Mr. Trebilcock represents, just to make that clear. I'm here today in support of our request to serve as an interested party in both recounts. I'm not going to belabor. We filed our request on Friday. I'm happy to answer any questions. But I would like to take a moment to respond to the comments you just heard from Mr. Hartman. First, I'm authorized to represent on behalf of my colleagues, Mr. Liedl and Mr. Trebilcock, and their clients, that we will coordinate and ensure that there is order and, not an excessive number of challengers at each table. And I certainly, on behalf of my organization, will coordinate all of the members of our coalition, which is not a new coalition. It's been around for several years. But we will coordinate and make sure that there's not an excess number of people serving as challengers. We will take care of all that. We believe that's our responsibility. We have a training scheduled for tonight. We are recruiting local lawyers to be with us, and we'll take full responsibility for all of that. So I want to have the board be rest assured on that. Now, I want to respond to the comments by Mr. Hartman, who seems to think that the local county boards of canvassers have any authority in this matter. They do not. It's very clear under MCL 168.889 that this board establishes all the procedures, the rules, the regulations, the process that govern this process. And that at these recount sites, either one of the board members is in charge or a staff member. And that's the way recounts have been done in this state for decades, and I've done dozens of them. I have never seen a recount, and it's an invitation for chaos to delegate to the county boards how they're going to enforce the rules, who's going to be a challenger. Those boards work for this board in this procedure under not only 168.889, but also 168.878. If there's a problem in this recount, our remedy is only against this board. We have no remedy against those local boards, and that simply reinforces the concept, legally required by the election law, that you all are in charge. And we expect and hope that you will adopt very thorough procedures today, and we will fully enforce and cooperate with all of those. But this is not a matter, cannot be delegated to these county boards in any way, shape, or form. With that, I'd be glad to take questions. If not, I'll step back.
Any questions?
You know, I would just say that I think we made it clear to Mr. Hartman that the county boards do not have the authority to decide who is an interested party, that is our job. And I agree with you, Mr. Brewer. I've certainly read the statute, and it is the responsibility, I agree with you that it is the responsibility of the State Board of Canvassers to conduct this election, that the county boards simply act at our direction and under our control.
And Director Brader, I enjoy putting you on the spot in these situations. In light of Mr. Brewer's comment, kind of getting to my concern, I think all of our concern about this devolving into chaos, if we as a board determined, okay, we will provide status to each of these groups, the 4 from Mr. Brewer's side and the 5 from Mr. Hartman's side, but designate a lead entity that coordinates and does the discussion at the precinct or county level. There's nothing prohibiting us from that, correct?
I think that's correct. Of course, if the Attorney General's office wants to weigh in, I welcome their involvement. But I think my view would be that the board, under its authority to establish procedures, in addition to its authority to determine who an interested party is, could limit the number of challengers able to observe each precinct at any one time to one challenger in support of and one challenger in opposition to the proposition, if necessary, to maintain an orderly recount.
Okay, thank you.
Does that make you a little like a tag team? So one in, one out?
Yes, and you know, we will accommodate and obey whatever procedures this board sets forth. And again, you will have a person on site at each of these sites, either one of you personally or one of your staff. And if they need to make decisions to keep order, they should be empowered to do so.
Mr. Hartman was shaking his head, but I'm not. May I address Mr. Brewer? If each of you can be trusted to sit next to each other, yes, please come up. I just did a 4.5-hour car ride with 3 young girls, so I'm not in the mood for any messing around.
The only thing I take issue of...
You got to turn your mic on.
The one point I take issue of what he states is the limitations of authority on the County Board of Canvassers. So I read that it states here under 885, the Board of State Canvassers or any members or representative thereof and the county boards of canvassers shall each have the right to subpoena any inspector of election, county officer, or other person to appear before it or him for any person as may be desired in connection with the matter of such recount. Once again, any purpose as such may be desired. So while I do understand that much like an administrative body sets for rules to carry out the law which the legislature passes, you are establishing the rules of the procedure and the time, manner, and place of the recount But unfortunately, I disagree that it is a authoritarian top-down. I believe the Board of County Canvassers has powers under the statute in which to exercise individual county-by-county judgment. That being said, the basic question we're here before right now is, as stated by Mr. Brader, and both of us agree, I believe that if you were to identify that one person as a challenger for and against from the interested parties as a matter of process is well within your bailiwick. But I do believe that the Board of County Canvassers does have some authority to investigate issues that come up. And they have the issue and the right to issue subpoenas. So.
Go ahead, Mr.
He misreads the statute. The statute says that the subpoenas must be in connection with the matter of the recount, not a fishing expedition, not an investigation, but if you have a recalcitrant local clerk who refuses to show up with the ballots, subpoena the clerk to bring the ballots to the recount. That's the limit of that authority. This is not some authority to engage in some fishing expedition for any purpose. And I would hope that if that happens at one of these boards, your person on site will tell that board they don't have the authority to go beyond what the statute says. It has to be connected to the recount.
That's my understanding as well, and that is, I really don't want to devolve into this, but that is a key concern of mine, that there are people acting in this recount request in bad faith, and that this isn't a count effort. This is an effort to get in and start filing subpoenas or the forensic audit nonsense. And that is not what this is about. If we can't agree on what this recount is about, perhaps we shouldn't proceed.
So, your comments aside, I agree that the limitation is for any purpose under the recount, but it does empower. The part I was making the emphasis on was not within the scope of the authority. I'm not trying to exceed the scope of the statute, but I was suggesting that each, the county board and the state board, that word each is in the statute. So yes, I didn't read the last clause, but I agree there's a limitation that it has to be related to the purpose of the recount. Let me give you an example. Let's pretend that a person shows up with their ballots and they're not sealed. The Board of County Canvassers can do an inquiry as to why the ballots aren't sealed. They could investigate that because the question is, a chain of custody issue is an appropriate matter for the Board of County Canvassers.
Member Gurwitz.
Yeah, it is my understanding that the purpose of a recount, the term investigation in the recount statute means that one investigates whether the ballots have been accurately tabulated. That is all that is involved, not an examination of a chain of custody or appropriate seal, of course, comes into play when the ballot containers are brought in. But there is no investigation of any issue other than whether the ballots have been properly tabulated. I would like Mr. Brader and perhaps council to confirm that, because I have the same concern that Member Daunt has just expressed, that this is an effort to expand the scope of a recount in impermissible ways. And I think it's important for us to clarify at the outset that your contention that these investigations can be undertaken through subpoena power at the boards of county canvassers is totally wrong, and I would like that confirmation of that from Director Brader.
The purpose of the recount is to determine if the ballots are tabulated properly. A sealed container is relevant to that in the sense that if the container is not properly sealed, that precinct cannot be recounted. So the board needs to determine whether the container is properly sealed. If it is not, then there are multiple ways of addressing that. If someone thinks that a crime has been committed, it can be referred to law enforcement in writing. It can be referred to the clerk or to the Secretary of State as the chief election officer for the state to determine if there have been violations of the election law. But really the board's job, the recount board's job is to determine if the precinct is recountable, and if so, to recount it.
May I address that just briefly? I agree with you, except I would note that I'd like to cite some precedent from what has happened previously in a recount. While it was a Detroit primary issue, this is from 2012. At that time, the Attorney General, Bill Schuette, issued a letter which indicated that he would not accept a referral for a criminal investigation, because what he indicated is that the next step mandated by the statute is the County Board of Canvassers to make a full and complete investigation into the allegation. In that case, it was of fraud. The language provides that upon a finding that there is probably cause, the canvassers shall conduct the investigation. The statute then gives express authority to subpoena witnesses and open ballot boxes that may be necessary during the investigation. While I recognize that the canvassers do not have investigative staff, the statute implies that they may call upon the county sheriff and Michigan State Police for investigative assistance. The County Board of Canvassers has a duty to make sure that there is no fraud or violation of election law. That is the basis of the petition, and that is an investigative process. I do have a copy of this letter that I can provide you. But it talks about the fact that it is not until after, and it says, it is only if the canvassers find after a full and complete investigation that there is good cause to believe fraud or wrongdoing or violation of law occurred during the election that the canvassers make a report to the prosecuting official and circuit court. This report requires the factual findings of the investigation and must be signed by a majority of the county canvassers. And he went on to describe how they had not completed that process because they didn't complete their investigation and that it was still upon them. Now, the reason I mention that is I hope we don't find any fraud or misconduct where statutes and rules weren't violated. I hope that we can dispel this because there's an accurate recount in every place. Where there is a problem, it is a requirement that the Board of County Canvassers, not the state canvassers, convene an investigation to determine whether there's probably cause to believe.
Mr.
And
Hartman.
if they make that finding, then it becomes a requirement for them to make a referral.
Mr. Hartman, I came to this meeting, and I think my fellow board members, with the intention of discussing this despite my deep reservation my knowledge that this is unnecessary and frivolous and ridiculous. But I came here with the desire to find a way to conduct this.
Do you need to recuse yourself for bias?
Excuse me.
You've already made a determination without a single ballot being recounted that you are biased. You've just called this frivolous and a waste of time. Do you not take your oath of office serious? Do we have quorum here of unbiased people?
Sir?
Sir.
I am here to determine a process to undertake the recount because I believe it's important that regardless of my personal feelings,
again, sir.
Excuse me, it is important for us to let people utilize the rights provided to them through our Constitution and the statute. This is a fishing expedition.
That's a prejudgment, sir, and I find that offensive.
This
Mr.
election
Allen put up significant amount of money in order to have a determination.
I will have you escorted if you do not let me speak and quit yelling over me. I am simply stating, my personal opinion aside, I want to find a solution that if this recount moves forward, that all sides can agree and that a proper count can be taken. A recount. This election has been certified. We are not going back in time to relitigate the issue. This is nonsense. I am sick of having to have this discussion with people, but it is your right to petition for a recount, and if things have been met according to statute, I believe we should proceed. You are giving reason to us to doubt that is what you're here for. Mr. Brewer, you had something to say.
Yes, thank you, Mr. Chair. With all due respect to the Attorney General in this letter that's been cited, there is a published Court of Appeals decision a few years ago. I came to this board on behalf of a client with Mr. Trebilcock, and we asked this board to investigate. The board deadlocked, we appealed, and the Court of Appeals found that you have no duty to investigate. So with all due respect, the authorities cited by counsel here is inappropriate, overruled by the Court of Appeals.
Mr. Hartman.
I would address, sir, that that is true, that the State Board does not have the authority to investigate. It's vested by statute in the County Board of County Canvassers. But that nevertheless, sir, I don't want to go outside the statute.
No, sir, let me ask you a question, okay? And bear with us, all right? We, to speak to Mr. Daunt's point, all three of us came here today to listen to petitions to perform a recount. We all came here with an open mind. We all came here with the idea that a recount would proceed and we would set up procedures. That's what I thought about when I drove from Grand Rapids. I've got a question for you listening to the opening here. You have 800, in the case of Proposal 2, you have 861,000 votes. That separates the win from the loss. You're planning to recount 38,000 votes. In the case of Proposal 3, you have 583,000 votes that separate win from loss, and you're going to count 479,000. So by your recount, it's not going to change any of the outcome of the election. So when Mr. Daunt's asking you if this is going to, if this is a way to walk into the counties and start a circus, he's asking you a question that I think I've got a question now about too. I didn't walking in here, but I do now. And that question is this really about opening up, is this really about trying to reopen this election on a county level because it was certified by the state, so now you're going to go to the county? I guess I'm not understanding what you want to accomplish.
Very well, sir. So let me address first of all that the only time you can do a recount on a state race or a petition is after you've certified.
Correct.
So in every case, that's when a recount occurs.
Right.
Secondly, I would state very clearly that the statutes you are probably most familiar with, because we all agree that this is a case of first impression or first experience, there's a difference, a huge difference in the language of 879 and 880. 879 requires that the candidate make a good faith belief that there is an opportunity to change the outcome of election, and it gives the opposing candidate the ability to object to the fact that there's a recount. Okay. In the wisdom of our legislature for 880, that is not the purpose. The purpose of an 880 recount is not to change the outcome of an election. Okay. It is based upon the fact that there is a reasonable belief that there is, and it's articulated in the recount petition, that there has been a problem with the election, and I don't have the language in front of me, but I can pull it up. But it does not specifically make the requirement that it changes the outcome of the election. When you read 880, it has a completely different statutory scheme. And what the prayer for relief is that the fraud or mistake be remedied. And that is the purpose of you do it. This is one of the few checks and balances that people have. And it is not to change the outcome of the election. It is to make sure that we scrutinize this process and that the powers that are vested in the County Board of Canvassers in a recount petition, that they look at this stuff. They look at the seal. They look at the chain of custody. They count the ballots. And that is the process. And I'll read to you the language because I see Mr. Brewer.
Before you do, could you just answer one from me? You used the word remedy, and I'm interested in that. Define what you mean by remedy.
I will cite rightly from the statute. It would be to correct the fraud or mistake. Okay, so under 880, the language is real clear. It states, any elector in this state who believes that there has been fraud or error committed by the inspectors of election in the return made by inspectors of any county canvassing board in the canvass of votes cast upon a question proposed amendment to the Constitution or any question or proposition, the votes of which are canvassed by the Board of State Canvassers may, not later than 2 days after final certification and determination of the Board of State Canvassers of the canvass of votes cast at an election, present to and file with the Secretary of State a written printed petition which shall be sworn to by the elector presenting the same and which shall set forth as nearly as may be the nature and character of the fraud or error of which the complaint is made, and the counties, cities, or townships, or the precincts thereof in which it is believed that the fraud or error occurred. And such petition shall contain a prayer of relief that the correction thereof may be made by a recount of the votes cast therein. That was what was stated.
The correction is the recount.
I understand the correction is the recount, but
you obviously do not.
Well, with all due respect, sir, I do, and the petition cites very clearly that one of the reasons that they believe a recount is necessary is because in the local races down ballot, there's a 20-point difference between the top of the ticket and the bottom of the ticket in some of these precincts. And so this gives reason and grounds, and it states that this right is if there's a belief, and that belief is sworn to under oath. And I understand the remedy is the recount. However, in the event that there is an error, or what happens if they do a recount and they discover that there is a significant problem? What I'm suggesting to you is that the statute, if you read its entire structure of the recount chapter, it's not that long. It states that the County Board of Canvassers has a duty to figure out why the recount was off.
Mr.
And
Hartman,
that's the key part.
Do you mean to tell me that that there have never been elections in this country, this state, your local municipality, where somebody at the top of the ticket gets more or less votes than somebody at the bottom based on candidate quality? Because that's essentially what you're arguing there, is that because people up here were terrible and got less votes than they should have based on down, that is a nonsense argument.
So that's only one of
the question before us. The correction is a recount to determine that things were tallied correctly.
Right.
It is not to examine for fraud or things like that. That
unless the
did
recount
not
discovers a problem. If the recount shows there's an error, that's the only time they pull the string and begin the investigation to make a referral. If the recount shows that everything adds up, the game is over. But if the recount shows that there is a problem, which happened in DeKalb County, Georgia in a Democratic primary, which happened in Cherokee County, Kansas, which flipped the result, which happened in Williamston County, Tennessee, all during the last 2 years. If there is a problem and it's discovered, then the Board of County Canvassers has the ability to investigate. If not, it's just a recount, sir.
Can I please get some clarification from the AG staff or attorneys on this claim that local Board of Canvassers can begin an investigation through the process of a recount? I simply have no idea where that's coming from, and I know people on both sides of the aisle, attorneys who come before us, like Mr. Brewer and Mr. Trebilcock, and on the other side, Mr. Doster and others who are not making that claim, who have not made that claim. And I think it's important that we note the ballot question committees set up to oppose these items are not here petitioning for a status as an observer. And I think that speaks volumes to their understanding of the results and what this recount will or will not accomplish. If you need some time, if you need a recess to take a look, I'm happy to do that.
This was not something we had prepared in advance to discuss
Could we maybe
in great
take a
detail.
10-minute recess or so and give you a chance to look at it?
Perhaps a short one. I would note, at least at the top of it, that of significance, I think, would be Section 889 of the Michigan Election Law, which provides that all recounts provided for this act shall be conducted in the several counties wherein the votes encountered were cast by the respective boards of county canvassers in each of the several counties, subject to the direction, supervision, and control of the said Board of State Canvassers. So ultimately, it is this board that is conducting the recount, and anything that would be pertinent to that. To get into more details about anything involving an investigation, we would need more time.
If we, and I'm not putting pressure for you to find this in 5 minutes or 10 minutes, but if we took a 5 to 10 minute recess to allow you at least look into it, would that be helpful?
It would be helpful.
Okay. We will recess. It is 3:16. We will be back at 3:30.
Thank you, Mr. Chairman. Thank you.
Tells me two things about you. Thank you. Do you know Les Turner?
No.
Sure you do.
Staff set to reconvene? Call back to order at 3:31 p.m. I think, in my opinion, the discussion with Mr. Hartman and Mr. Brewer, unless Mr. Brewer, do you have anything else to add? I think maybe that portion has exhausted itself. And I'd like to get to the other individuals who have requested to speak on this issue.
One final comment, Mr. Chairman, if I may.
Sure.
I just want to reemphasize MCL 168.889, which gives the exclusive direction, supervision, and control of the recount to this board. There is no independent authority for a county board to do anything other than what this board directs them to do. Thank you, Mr. Chairman.
Thank you.
Sorry, Chair Don, could I just ask one clarifying question? Yep. Mr. Hartman, those organizations, are they seeking to be an interested party for both proposals 2 and 3, all of them? Okay, thank you.
Okay. Gentlemen, got to turn your mic on. And
Honorable Mr. Don, I would like to indicate I agree with that statement in section 889. It goes on to state that the board shall prescribe the time and place in each county where the recount of votes shall be conducted, wherein the recount shall be in public. It says, said board shall provide each board of county canvassers with such rules and regulation as in the opinion of the Board of State Canvassers shall be necessary to conduct such recount in a fair, impartial, uniform manner in these several counties. Observance of such rules and regulations shall be enforced by said board or its representatives hereinafter provided for. So, Your Honor, Honorable Chairman, I think it is very clear that the Board of Canvassers sets the time, manner, place, and the rules, and is responsible for enforcing the rules, but that the recount is conducted by the county canvassers. That's what 889 says to me. And under 891, it goes on to say that any recount.
Mr. Hartman,
yeah.
I think we're
okay.
We're sending this horse to the glue factory. That nobody else, I think, agrees with that interpretation, and there are avenues to address that that is not this board. I think the interpretation or the clear language rather is that this is to be conducted by the state Board of Canvassers and the individuals that we authorize. And so with that, I will dismiss both of you gentlemen and call up either Mr. Trebilcock or Mr. Liedl, whichever you would like to go first. Mr. Trebilcock, you are an attorney licensed to practice law in the state of Michigan.
Yes, sir.
Please spell your name.
Chris Trebilcock. Trebilcock is spelled T as in Tom, R-E, B as in boy, I-L, C-O-C-K.
Okay, go ahead.
Good afternoon. I'm here on behalf of the Ballot Question Committee, Promote the Vote 2022. You know, it's one of those things you come here with a playbook and then things play out. And so I'm going to keep my comments brief and to the point. One is, I'd urge this board to think about what the term interested party means as you consider recognizing who is an interested party. I think clearly the ballot question committees and those organizations who help fund, organize volunteers, collect signatures, and appeared as challengers for both of those proposals are interested parties and should be recognized. But certainly for that term to mean anything, there has to be standards or definition to it. So I'd encourage you to think about that. Second is that I think Chapter 33, and Mr. Brewer certainly expressed it very well to this board, is that Chapter 33 establishes procedures for recounts. And the recount process is very narrow. And I'm not sure if Mr. Hartman has not been part of a recount or attended a recount, but I find in my experience when I've been there, people who haven't been through it before think that it's something that it's not. It is a very narrow, limited process to simply verify the count of the ballots cast. Nothing more, nothing less. The powers and the rules that are established are to ensure that the count that you do again is is done well and properly. The powers that this board has and the things that you look into are simply, what do we need to have necessary to do a recount of the ballots cast on Election Day? It isn't to get into chain of custody issues, into investigations about how a seal may or may not have been broken. All of those things are outside the purview of a recount. And so again, the order and the process established by the recount and the rules and procedures adopted by the Bureau that's applicable to candidates is appropriate and necessary. I think your points, Mr. Daunt, are well taken. You know, you spent 4.5 hours with your daughters or with teenage girls. I spent yesterday in the yard with 3 boys, including 2 twins under 3, and I got them whining and crying about how the process wasn't fair, that their brother kept beating them, who's 8 years old, in races. You know, the outcome is not going to change. These arguments are tried and have been rejected by the courts. Let's not forget that a lawsuit in Wayne County was filed making these same almost identical claims about how the process, and our former Director of Elections, Chris Thomas, testified for hours on end, beating back every debunked conspiracy theory that was put forward in regard to these election systems. These are no different than another iteration of those. So this is, as you said, Mr. Daunt, a waste of time and money, but if the statute provides that it is a right to have that, waste that time and money, then we have to exercise that right. But again, to close, I'd urge the board to focus on what is and what does it mean to be an interested party, and making sure that there is a process that ensures uniformity across a recount, as well as that it doesn't devolve into a debacle. I have confidence that with my colleagues, Mr. Liedl and Mr. Brewer, that we'll be able to meet the demands and the rules put forth by the board and keep it limited to the number of no excessive individuals at the counting boards when reviewing the count. So if there's any questions, I'm happy to answer them, but I thank you for your time and your work today.
You knew I was going to have a question for you.
I'm just glad you didn't go
I
to
wouldn't
sleep.
miss. No, I stayed awake this time.
All right.
I haven't read any more of your briefs. That wasn't very nice. I'm sorry.
That's all right. I take it.
Here's my question for you. Mr. Hartman has a list of 5 interested party organizations that he's put forth. Do you have multiple organizations that you're putting forth as interested parties?
Well, there's the ballot question committee, who I represent, which is a separate and distinct entity from the sponsor, which is Promote the Vote. Promote the Vote has been in existence longer than the ballot question committee has, and its sphere is much broader. Mr. Brewer can talk about that. I think he detailed it in his substance, but there are many organizations that make up Promote the Vote, and those individuals fall under that umbrella. I think it's important to recognize that being an interested party comes with it duties and obligations, which is to adhere to the rules put forward. Who do we sue? Who can be charged with a felony if they're interfering or take some conduct during these recounts? There has to be a responsible party, and that's why there is a recognition of interested parties. And so in our case, we've got Promote the Vote 22, the ballot question committee, that has asked and requested to be an interested party. Then there's the nonprofit umbrella organization of Promote the Vote that has done it. And that's just talking about Proposal 2. I believe Proposal 3 has asked on their own behalf for those. That all being said, we're all already in agreement that we're going to coordinate our training and the challenges that are present at the precincts and the tables.
Question? I think that's actually a very helpful point about the names of the groups here for accountability, so that if things do go haywire, there is somebody at the top that is in charge and responsible for these people. So,
absolutely.
Thank you. Thanks, sir. All right, Mr. Liedl.
Thank you, Mr. Chairman and members. If it's okay with the chairman and the members, I've got 2 handouts. One, I just wanted to have a copy of the statute handy in front of you, if that's okay. And then earlier today, this morning, I'd sent some correspondence to the board and the secretary that referenced an opinion and order on many of the issues raised by the individuals and groups seeking the recount. And I believe I only attached one of the pleadings, not the opinion and order. So I wanted to make sure each of you had that and that was in the record as well.
Yeah, go
it's
ahead.
Okay, I can approach.
Bring it on up, and then when you get back, spell your name for us.
Sure.
And you are an attorney licensed to practice law in the state of Michigan. I assume you won't take 45 minutes, so go ahead and let us know what you've got to say, and we'll kind of move along from there.
Yes, I do have a few additional issues to raise. I would like to take a couple minutes to do that, given the time that's been provided to others. I appreciate your service as members of the board here today. It's Steve Liedel, L-I-E-D-E-L, of Dykema, representing Reproductive Freedom for All, and I am an attorney licensed in Michigan. And I would like to address first the coordination issue. Reproductive Freedom for All has previously agreed that we will coordinate activities with Protect the Vote. So there'll be, similar training of volunteers in a joint effort. And if there's a situation where Protect the Vote is the interested party designating an individual for a particular recount, Reproductive Freedom for All will not, and vice versa. So we'll avoid double coverage and coordinate. And I do think, as an additional item on the concept of interested parties, remember that any organization that expends resources in support of or opposition to a ballot question or raises money with regard to that effort under Michigan law, in this case the Campaign Finance Act, is obligated to either register as a ballot question committee, or if the expenditure is an independent expenditure, report those independent expenditures. I think that's another basis for determining who is or who is not an interested party because of the obligation to take those actions. And Reproductive Freedom for All is a registered ballot question committee complying with its obligations to report expenditures and contributions under the Michigan Campaign Finance Act. If I could, I wanted to step back in part to address, sort of a more threshold issue that you've not heard today. It was addressed in my correspondence to the board. I'm not going to go through that in detail. I would like to highlight a few items. In essence, I think this may help address some of the questions raised by Member Daunt and Hauskamp with regard to the purpose and the scope of a recount. But I do think we should start at the beginning, which is always the text of the statute. And as I read the statute, you should not be here today. MCL 168-880 establishes minimum requirements for a petition to recount results for a proposed constitutional amendment. The petition for the recount of votes for Proposal 3 does not meet those statutory standards. The petition before you does not meet the standards for a recount petition. I urge you to look closely at the language. The Secretary of State should reject the petition, and the board should as well, and not adopt any procedures and not conduct a recount because the statutory requirements haven't been met. It isn't just like, well, I disagree with the results of an election, and so I want a recount, and so I can say I believe in fraud or error or believe that there should be a recount. That's not enough. The statute is much more specific, and this board has a duty to faithfully apply that statute. Wanting a recount is not enough. Believing that the recount might change some results is not enough. Speculation or theorizing doesn't cut it under the statutory directive of the legislature. More than a belief that fraud or mistake has occurred is required. The statute begins by saying who is eligible to file a petition. And that standard's pretty simple, right? You just have to have a belief that there was fraud or error in a return by county election, by election inspectors, or in a canvass of votes. It's not just any fraud or error. It has to be fraud or error in a return by election inspectors or a canvass of votes by a county board of canvassers. That's a threshold for you to be statutorily eligible to file a petition. You can believe anything. You can believe the earth is flat. You can believe the World Economic Forum, controls government bodies throughout the country. You can believe anything. This is a free country, thankfully. But that is just the minimum standard to who can file. So who can file? Well, you just have to believe that there was election or fraud, fraud or error in a return or canvass. That's not where the statute ends, though. It's not enough just to have a belief, all right? The statute has 5 mandatory elements, and the petition has to satisfy those mandatory elements in order for the petition to be within the scope of a petition for recount that the Michigan election law recognizes. We've discussed the belief. That's the first. The second is that it must include a description of the nature or character of the fraud or error in the return by election inspectors or a canvass of voters by a county board of canvassers. It's not enough to describe conduct with someone who perhaps configured an election machine, a tabulator machine. That's not a return of election results. That is not a canvass of votes. That's outside the scope of the statute, okay? So the petition must address only, under the statute, fraud or error in the return by election inspectors or a canvass of votes by a county board. Then the statute goes further. It requires specific information with regard to the counties, cities, or townships or precincts where the described fraud or error occurred. So it's not just enough to say, well, we think there's some fraud generally. It may or may not have been done by election inspectors or a county board of canvassers. Specific information is required by the statute about where. And the petition lacks that. There has to be a sworn statement by the elector. That's a mandatory element. And then there has to be a prayer, to use the fusty lawyer's language that they would use in the past to distinguish themselves from folks that use ordinary words. It's a request. That it's not prayer in the spiritual sense. That the fraud or error identified in the specific locations can be corrected by the recount. And that is the purpose in the statute of a recount of a proposed constitutional amendment. It is for the purpose of correcting any fraud or error by a return of election inspectors or a board of county canvassers. If, for example, one of the returns or canvasses is incorrect or there's some fraud. And we know here, based on the plain language of the petition submitted, that it doesn't satisfy the statutory requirements. There's no description of any fraud in the petition before you. None. The petition doesn't describe an error in the return made by election inspectors or an error in a particular canvass of a particular board of county canvassers. You can go through each of the 7 allegations made in that petition. You should cross out anything that is not a description of fraud or error made in either the return by election inspectors or a canvass of votes by a county board of canvassers relating to the November 8th, 2022 general election. You have to ignore the information that's in that petition about prior elections. You have to ignore the information about elections in other states. That's not a basis for a petition for a recount under our statute. Folks may want it to be. The remedy is not before this board, it's with the legislature across the street. They can change the law to provide that basis, but right now it's only the basis authorized in the plain text of the law. So when you're done with that process and you remove anything that's not related to a specific return in a particular locale by election inspectors or a county board of canvassers, you'll find that there's nothing left to describe errors or mistakes as the statute requires. There's just nothing there. There's some speculation, there's some theory, there's references to other states. That's not a basis for a petition for recount under the statute that you have a duty to enforce. Certification of machines or lack thereof is not a permitted reason for recall under our statute, nor is an internet connection or a lack of an internet connection. The statute doesn't address that. It's outside the scope of the statute you are administering today. Underperformance by Republican candidates at the top of the ticket is certainly not a basis for a petition for a recount. That's just ridiculous. There's always underperformance, depending on the candidates. Folks' willingness to support particular candidates varies widely throughout the ballot in state and local elections. Things happening in other states, the statute requires more. You can't look at things in other states. So for those reasons, it's our position at Reproductive Freedom for All that the petition should be rejected by the Secretary of State as non-compliant with the statute. You shouldn't proceed with the recount because it's not sufficient. That's our position. We urge you not to proceed with any recount of Proposal 3, given the plain language of the statute. Now, if you choose to establish procedures for a recount, there's a couple items I'd like to highlight. The first page of the petition submitted by the proponents of the recount has a handwritten note, right? It's not part of the actual text of the petition. I don't know when that was added. Was it added after the petition was filed? I don't know. Was it added after the sworn statement was attested to by a notary public as required under Michigan law for a sworn statement? There's initials, or at least 2 letters. They appear to be initials in a circle. That's SL. Those happen to be my initials. I didn't sign this in my handwriting. I didn't sign this petition. But they're also not the initials of the petitioner. The petitioner is James Allen. He has a middle name he uses in the petition. Jerome J. Allen, I apologize. And it's notarized by Matthew Lair. So I don't know if this statement, where the request is apparently to include all in-person and AV counting board requested for all attached precincts. I don't know what that means, right? And it certainly doesn't satisfy the statutory criteria to specifically identify a county, city, or township or precinct in which you believe an error or fraud has occurred. There's no authority for general like any and all. And so to me, this means that in determining the precincts, if you decide to do a recount that should be recounted, you have to ignore this handwritten statement. It's not consistent with the requirements of the statute. It's not specific, and there's no indication that this portion is a sworn portion of the petition. All the other reference in the petition and the sworn statement is only to the typed petition itself. And there's no authority under the statute to supplement, modify, or clarify. The complete petition was due 2 days after your certification of the election. So if it wasn't a complete statement, complete petition that complied with the statute, there's no remedy after those 2 days. It either was 2 days after the election or it isn't. It either is part of the sworn statement and was or it isn't. No remedy for this board to consider at this point. The last point I'd like to make has to do as you determine your procedures for the recount. I actually have, I think, just two more points. The number of precincts requested. I heard a reference earlier from the Bureau to 909, I may have the number wrong, precincts being subject to a recount. I'm looking at the actual petition. I see 560. So the statute says specify the city, county, township, or precinct. I see 560 listed here. Now, there may be a question with regard to absentee voter counting boards in the city of Detroit. But I think it's important for the Bureau and the board to be aware that the statute addresses that. Right? what we have beginning on item number 420, 419 of the petition before you are references to absentee voter counting board numbers in the city of Detroit, but no individual election day precincts. Now remember, in the city of Detroit, there's specific provisions of the law that indicate that absentee voter counting boards in Detroit are not associated with individual precincts as everywhere else in the state. They could be county boards for multiple precincts, might be 2, might be 7, it varies. As long as all of the races and proposals on the ballots align, absentee voting counting for those particular areas are consolidated. But most importantly, the statute, the Michigan election law, speaks to this. MCL 168.59A 2 and 3 provides as follows. Except as otherwise provided in this subsection, an absent voter counting board is a separate precinct for purposes of this act. If a municipality has 250 more precincts and absent voter counting boards are used, each ballot form which controls identical offices and names may be considered a separate precinct for purposes of this section. That last sentence is a reference to the city of Detroit, which has more than 250 precincts. Then the section goes on. Notwithstanding provisions of law or charter to the contrary, this section applies to nonpartisan general elections and to municipal elections. So here, we know what a precinct is. And for the city of Detroit, an absentee voter counting board is a precinct. And so I see no request in this petition for any precincts that are election day precincts to be counted. And so I would urge the board, when you adopt your procedures for the recount with regard to these issues, to 1, ignore the handwriting written comment, which is both statutorily deficient and apparently not within the scope of the sworn statement, and 2, not permit the recounting of any precincts in the city of Detroit other than those precincts designated as absentee voting counting board precincts in the petition itself. Any other recount of other precincts would be inconsistent with the statute and the petition before you. One last threshold item with regard to procedures, and I would urge you to be specific as possible given the declared intent in the media and otherwise of this recount, which is not a recount consistent with the purpose of the statute, as Chairman Dott has suggested. That's clear based on the media statements of those who, public media statements of those who support this recall. And that is, make it clear in your procedures that this is the Board of State Canvassers recount, that county boards of canvassers have no authority except as authorized by the State Board of Canvassers in its procedure. They're acting as your agent. I think more importantly, a fact that was ignored by counsel for the petitioner, that's consistent with state law. State law is clear generally. Governmental bodies, whether it be this board, the County Board of Canvassers, have no inherent and implied powers. They only have those powers expressly granted to them. And so you can't imply that a county board has powers to do things otherwise. It also would lead to chaos. We can't have 47 different recounts counted with 47 different standards for a statewide proposal. So I'd urge you to be clear. And lastly, with regard to the subpoena authority, I would note, and I would urge you to include this in your procedures, the statute authorizes the County Board of Canvassers, not individual members, not agents of a County Board of Canvassers, to grant subpoenas. That's a governmental body. That means the board would have to meet in a meeting that complies with the Open Meetings Act, and a resolution authorizing a subpoena would have to be approved by at least by a majority of the board with at least 1 member from each of the 2 major political parties. I think that should be clear because it's clear based on the testimony today that the proponents of the recall have a problem with a basic reading and understanding of the plain text of the Michigan election law. I think the clearer you can be, the easier the job for everyone involved. The clearer you can stick to the statute, the more likely we will be in a situation where folks have confidence in the integrity of our election and the manner in which this recount is conducted. We don't need a clown show. We don't need chaos. We need clear procedures consistent with the plain language of the statute. And with that, I'd be happy to answer any questions you may have.
Any questions from our fellow members here? One thing I'm thinking through, and maybe I'm not sure this is a question, but your last point about plain reading of the statute and how clear we are here. I understand where you're coming from and what you're saying. My concern is having this body get into the practice of laying out 15 different things that the statute doesn't mean, and when all reasonable people are agreeing that it means and what it says, and ultimately the courts exist to help settle those type of questions. So again, I don't think that's necessarily a question. That's just something I'm thinking through in terms of those types of requests. I think you have a valid concern, but ultimately the statute is quite clear.
Yeah, I think, if I may, Mr. Chair, I may have a suggestion that perhaps you'll find helpful. I wouldn't rewrite the statute or write new procedures. I do think, given the circumstances, it would be clear, that the state board, in its direction and supervision and control of this process, is very clear to the county boards that, for example, in the case of a subpoena, one may only be issued in compliance with the section authorizing, under the election law, a subpoena, and that the subpoena must be limited to the purposes authorized under that provision as well. I think that you could also make it clear that if there's any ambiguity with regard to the interpretation of any procedures or direction that you provide to the county boards, that you make it clear that there is clear authority to any agents the board designates to conduct the recount in your behalf at the Bureau, so that they can resolve definitively those issues and that you don't have groups fighting over them. And then, they will have the benefit of counsel from their career civil servant attorneys at the Department of Attorney General, who always serve you and the Bureau well and have a good understanding of what the law requires. And if then there is still an actual live dispute, there's a mechanism for final determinations by state entities to be reviewed by the judiciary if necessary. I wouldn't suggest rewriting or detailed new procedures, but given what we've heard today, I suggest it would be, in the interest of all involved in terms of a proper recount in compliance with the statute and assuring the public about the integrity of this process, that it's clear the plain text of the statute must be followed by the county boards, and they have no authority beyond the relevant sections of the election law relating to this recount.
Thank you, sir. And other questions? I've got a couple for Mr. Director Brader related to some of the things you mentioned. I don't think it's a shock to people who pay attention to this board that there's often difference of interpretation of certain items related to our authority. I will ask Director Brader, in your opinion, the opinion of legal counsel for the board, have the petitioners satisfied the statutory requirements for a recount in what has been presented to us?
In the view of the Bureau, yes. We received the petition, reviewed it, and determined that it was appropriate to present it to the board. But I'd be happy to defer to the AG on any of the more legal arguments about the specific language of Section 880.
This was something we did have a chance to look at before the meeting started. I think, at least initially, it's probably worth mentioning that with respect to Mr. Lidl, the Michigan election law does not specifically provide for objections to recount petitions for constitutional amendments. Section 882 provides for opposing candidates to file objections to recount petitions. However, there is no similar provision providing for objections to by ballot question committees in the context of a constitutional amendment. Turning to the substance of the objection, regarding whether or not the claims of fraud or error in the petition were not sufficient. Section 880 does not include a particular threshold for claims of fraud or error in a petition. Instead, it requires that a petition set forth as nearly as may be the nature and character of the fraud or error of which the complaint is made. Even if the claims of fraud or error were wrong, incorrect, unfounded, or whatever else would be the basis for arguing that they're insufficient, I have found no legal authority for this board to either refuse to perform a recount or to reject a recall petition on the basis of the board's determination that the claims of fraud or error were insufficient to justify a recount.
Thanks, sir. And you look like you might have a question.
Yeah, actually, I find Mr. Lidl's argument quite persuasive, because I do not see that the petition alleges that the fraud or error, which they reference, was committed by the inspectors of election in the returns or by the county canvassing board in the canvass. Nor does it set so there are, of course, these allegations of fraud and complaints, as noted, many of which have already been addressed in court. But I think the very specific language of 880 does require that the fraud be fraud or error not committed by the Board of State Canvassers in failing to certify the election tabulators or the software or hardware, which in fact we have done. But it has to be fraud or error committed by the inspectors of election in the returns made by the inspectors or by any county canvassing board in the canvass of votes cast upon the question of the proposed amendment. So they are asking for the recount of, I counted 53 counties with regard to Prop 3, and they have not alleged that any election inspectors in those jurisdictions in those 53 counties or any of those 53 county canvassing boards have committed fraud or error in their canvassers. And we know that that 83 county canvassing boards have already certified the results of the elections in the counties for which they have responsibility. So I just, I know that there's an inclination just to go ahead and do it. It isn't going to make any difference. We know it's not going to make any difference. It's going to require a lot of work by the Bureau of Elections, supervising as it must in detail the work of county canvassing boards. It's going to require a significant expenditure of time and resources by all of these counties and by these jurisdictions within the counties. So I think before we go ahead and say, yeah, why don't we just do it, I think we really need to look very carefully at that language in 880 and determine whether or not we're satisfied that the petitions have alleged a sufficient reason for a recount to go forward. And I understand what Mr. Grill says, that there is nothing in the statute which allows for somebody opposing a recount where it involves a ballot question. I don't think that that means that the board necessarily is without the authority to decide that a petition is insufficient.
Go ahead. You had a counterpoint, then
I'd like to just counterpoint just one point. I don't know if it goes anywhere, but the country right now, the state of Michigan right now, people are talking about fraud in an election, and this fire continues to burn. It's burning all over the country. It's burning here in Michigan. We've seen no fraud. We've seen a very clean, very clear election with a lot of people putting a lot of work into it. But that hasn't stopped it hasn't stopped the noise. And right now, we have a request for a recount that won't go anywhere. But by turning down that recount at this board level, my concern is that all we're going to do is we're simply going to amp up the noise, and we're going to create more heat in the fire. And at some point in time, maybe fire is the wrong word to use. I have the feeling like we're playing golf in the middle of a really fine, porcelain store. And so far, nobody's hit anything important, right? But we keep walking down this road where we're at war with each other, and there's the allegations of fraud that simply don't exist. And if we shut this down now, I would almost rather have us look at it and say, if we can't shut it down, if we need to go forward with this, to follow through, Steve, with what you said, make sure there are really, really crystal clear, really iron guidelines as to what's being recounted, as to what the terms are, as to what the subpoena power is. We have to fix this democracy.
I'll let you go.
Yeah, if I may, Mr. Chair, I want to be clear. The information provided today is not in the form of an objection to the petition. I understand the distinction that the legislature has used in the provisions it's provided for recounts relating to candidates and recounts related to proposed constitutional amendments. I get that. I can read the statute. But if it is not a petition for recount that satisfies all of the elements of the plain language of the statute, then you have no petition before you, right? And you can't insist on the rule of law, for certain election provisions and not others. If you're committed to the rule of law, the last I checked, the conservatives that I knew or used to know were committed to applying the plain text of language enacted by our Michigan legislature as plainly written. And I think, with regard to the other allegations of fraud or mistake, to use the term used in the petition, those have already been addressed by the Third Circuit Court and found severely lacking, right? And so in terms of, what about these issues about voting machines and certification? Asked and answered. If this were a court, there'd be a collateral estoppel motion because the court's already addressed these legal questions. There's not a question. I mean, do we believe in facts? I do. Do we believe in the rule of law? I do. Do we believe that this board and the Secretary of State should take seriously their duty to implement the statutes they've written? I understand, it's a valid concern. We all want to find ways in which all of us as Americans and Michiganders can work well together. That doesn't mean, though, enabling conspiracy theories and doing things inconsistent with a statute when the plain language of the statute requires otherwise. And here, the legislature has been clear. They had an opportunity to rewrite the election law, and they did after recounts that occurred in 2016. If folks were dissatisfied with the recount process, they had the opportunity in the appropriate venue under our Constitution with their elected representatives in the legislature to alter the election law to allow for a petition for a recount, let's say on the basis of the configuration of a tabulator or the certification of a tabulator. That's not what the legislature has said, as Member Gurwitz has clearly pointed out. The statute requires a detailing of the error or fraud with regard to returns by election inspectors, specific election inspectors in specific locales, or county board of canvassers in their canvass of votes in a particular county. This petition is lacking in satisfying that statutory mandate from our legislature. That's my position, and I appreciate the opportunity to make those arguments and preserve my exhaustion of administrative remedies.
Thanks, sir. Other questions?
The only question is do we know where did that handwriting actually come from?
So this was delivered by Stephanie Lambert, and during the course of reviewing the petition, Bureau staff it wasn't clear to Bureau staff whether the intention was to seek a recount of only the county board precincts in Detroit or also the in-person precincts. And then she said it was in person as well. So at that point, she added that note to clarify that that was what was being sought.
Oh, if I may, Mr. Chair, then that clarifies. This board has no authority to consider that
Mr.
written
Hartman,
statement. There's no
Mr.
sworn
Hartman,
statement. There's no sworn
haven't called you
statement.
up.
Excuse me, I'm testifying.
I haven't
Mr.
called you
Hartman.
up.
I'm in the process of testifying. I follow the rules and the rule of law, sir.
Since he's testifying, please.
Mr. Hartman, I have already asked you to behave in a responsible fashion. I don't want to have to do it again. Do not approach while other people are speaking and call out from the crowd. Mr. Liedl, sorry about that.
Yeah, I appreciate the clarification of the director as to the source of that statement. And I think it further emphasizes my argument. I believe the board should consider it, that that element of the petition before you doesn't satisfy the requirements of the statute because there's no indication of any sworn statement from a Stephanie Lambert or anyone else with the initials SL. It certainly will make everyone's job easier in terms of the number of precincts that need to be recounted, and it's clearly consistent with the plain language of the statute. No one is entitled to a recount that they're not statutorily entitled to, just as no one is entitled to file objections under the statute.
I think Member Gurwitz has made a solid point. You have made a compelling point as well related to the lack of proper compliance with what's been laid out. I'm struggling, perhaps Member Hauskamp is as well, with the idea of this board substituting our judgment on stopping what is a process in law that is allowed to these individuals. Where I'm gaining some clarity is I came into this process understanding that these individuals met the statutory requirements. It was what Mr. Grill said about the lack of an objection process as well as no authority for us to deny a recount. But then counsel for those seeking came and torpedoed that, in my mind, of the good faith effort nature of this recount and what they were seeking. And I don't know.
Can I add one more
if
to
you
that?
have something to add.
Especially with this gentleman sitting here in front of us. It was less than 2 months ago. We had a long conversation about the validity of spaces. You might not remember that. I do. And there were a lot of folks in the room that went along with that idea, that, hey, spaces are important. That was part of the form. That was part of what was legitimately our argument. And I know we had folks on the board here who didn't believe that. But I guess here's the reason for bringing it up. You're raising a specter here of a legal document that was filed. And you're saying that the form on that document with the handwriting and with the way it was filed or what was in the substance of filing, if I'm hearing you correct, you are saying that that violates the same equivalent of form. I guess one of my points is what's good for the goose is good for the gander, right? I mean,
well, I think,
or does that just obfuscate it worse?
Yeah, to respond, Member Hauskamp, in that instance, we made the argument that the plain text of the statute did permit.
I know you did, but I'm saying that
we
we went against you on that. But in this particular case, the other side has got a form that's been turned in that, if it's not in proper form, is that what we're talking about here?
Well,
I
think I've been consistent before this board. We had a number of petitions which I objected to for candidate nominations that didn't satisfy the requirements of the election law. I objected to those. In my view, I also didn't contest a number of candidates who were eliminated from the ballot for not qualifying. Right? I think that in the case of the petition for Proposal 3, again, totally different statutory requirements, that proposal did comply with the statute as confirmed by a bipartisan majority. And the remedy, you know, when you submit something
I'm actually not arguing that. I'm simply arguing that right now we're almost with the same thing where we have a document that's been filed that, if I hear you correct, you are saying that that document that's been filed with Mr. Brader and his group is not a legitimate document because of the way it was put together.
I'm not going to say it's not legitimate. I'm saying it doesn't comply with the mandatory elements of the statute, and I think in two regards. One, just generally, by failing to make specific allegations of fraud or error with regard to returns by election inspectors or canvass of votes by county boards of canvassers. I think the second piece is more important, this handwritten, as important, this handwritten note that is not sworn. It's not part of the sworn statement. It would be as if, you know, you had an oath of office or an affidavit of candidacy where someone else other than the candidate wrote something on the sheet and then asked this board to approve it as if it was a sworn statement of the candidate or the person making the oath. So those are the two arguments that I've made. I'm making today. I'm a lawyer. I believe they are solid arguments. I believe it's consistent with the plain text. You know, that's my obligation on behalf of my client. I'm also preserving administrative remedies, which is important in the event there's any litigation. But in terms of my position, I think it's clear. And if, you know, the board decides, you know, I don't care if the board decides for or against me. I think if the board acts inconsistent with the law, I'll go appeal it to the court. In the case of the Proposal 3 petitions, we did to the Michigan Supreme Court. If anyone else is aggrieved by a final determination, either by the Secretary of State or this board's action or failure to act, our Constitution gives everyone the same rights.
I think ultimately, in the interest of time on this, I mean, my time on this board, what does the law say? And then if there's disputes, interpretation, what is the legal court precedence? What has been in the court system previously? If people recall May, when we had the big hearing about candidates and ultimately five Republican candidates for governor were disqualified because of fraudulent signatures. I was pretty clear at the time that I thought the work that the board did reviewing them was legitimate and held up, but ultimately erred on the side of access to the ballot for those individuals with the knowledge that the courts somebody would appeal and the courts would have a say in this and clean this up, and now there's precedent on that because that was an unprecedented matter. I view this as the same way, as I personally think this is a gigantic waste of time. I think it is poisonous to our system. I'm sick of having this argument. It's exhausting. It's been 2 years, and we continue to have this. However, the law doesn't provide us a remedy for dismissing this. They have a path for them to file for a recount, and I have faith that the Bureau of Elections staff has dealt with other challenging situations and that they will be able to do so. So, setting my personal thoughts on the validity of this, I intend to vote for this recount to go forward, provided we establish some guidelines. We need 2 votes, three votes for this to occur, depending on where those votes fall. So I wanted to lay that out as to what my intention is. I appreciate your point. I think it's well reasoned and well taken, but ultimately, we don't have the authority, as it's been laid out by our council, to reject this. I think we should lay out guidelines so that it proceeds smoothly, and there's accountability for people who seek to undermine that process moving forward.
Thank you, Mr. Chair. I appreciate all your time and effort. I'm happy to step aside unless there's any further questions.
Thank you. Thanks, Steve.
Just as a note, the sergeant is going to ask us to leave at 4:30, so we have to wrap whatever we're going to do up quickly.
Will they give us?
We can't make a motion to stop time.
They're not going to.
We could, well, we can see. We can try to stay.
Question for you. We've got 2 minutes left. So if we take a vote, that means to me we still have this whole issue of setting up forth policies and procedures.
Like, I believe we can lay out, number one, we have before us the recommended procedures to follow.
Okay.
Which Director Brader laid out is consistent with what they've done in other recounts. So we would be adopting those procedures, and then secondarily would be adopting or ratifying who is an interested party. And I believe we could knock those out relatively quickly, and I think perhaps the sergeant, if he knows we're wrapping things up, would give us a little time.
Couple minutes? One question about wrapping it up with the list of interested parties. Can I ask you guys a question? Can we also establish, as we talked about earlier, that interested parties are listed? So if there's, you know, we know we've got a whole bunch of pieces here, but as part of the stipulation of whatever we do today, if we go forward, can we stipulate that both sides will list out the organizations that are in one list, not in a bunch of separate pages?
If I could quickly clarify, I think for purposes of 2 and 3, it's promote the vote, Michigan Democratic Party, and the organizations that Mr. Hartman submitted. For proposal 2, it's promote the vote 2022. And for proposal 3, it's reproductive freedom for all. Those would be the lists that apply to each motion.
And for clarity and legality, et cetera, should we take the time to list those all individually in the process of the motion?
Yes.
Okay. So if we may perhaps take a recess to, if there is a motion somebody would like to draft.
A recess while we draft up the motion to go forward. Is that the right way to say that?
Just write down the names. We can just write the names on there for you, if that's easier.
Yes.
Okay.
Okay. Okay.
I would, with regard to the designation of interested parties, I believe that Mr. Tabilcock was correct in saying that the parties who are interested, who have been recognized as interested from the beginning, are the ballot question committees, the nonprofits, such as Promote the Vote, and those opposing the ballot questions. As Chairman Daunt noted, there are no parties here who oppose the ballot question. Those parties which have filed the appropriate, papers and reports with about their campaign finance matters, et cetera. So I think we could, I think we should, assuming that we go forward, recognize or approve the interested party status of those entities, Promote the Vote 2022, Reproductive Freedom for All. And I would suggest that with regard to the petitioner, we approve Jerome J. Allen as an interested party, and the entities which he intends to use to serve as challengers and observers would not need to be specifically identified by us as separate interested parties. I would propose that we only recognize the petitioner as an interested party.
Based on the reasoning, I have no initial concern with that. Does that make sense from your standpoint, or from a staffing standpoint, is it easier to have those organizations?
It doesn't really make a difference to us. The only issue is whether it will create any confusion or disagreement at the recount. As long as the challenger entity can coordinate, I don't think it's going to matter.
So that's the responsibility then of that individual or that group too.
Figure out who his challengers and observers will be.
Mr. Hartman, is that agreeable in terms of allowing this to move forward based on the inclusion of Mr. Allen as an interested party, and you coordinate from there?
Sir, the only point I would make is that when a person presents to the board of county canvassers at a county level and says, I'm the designee, there's no real way to check the credentials. So I think that we would be willing to provide some form of supervision and oversight. However, all these people have credentials from their previous experience as poll challengers to affiliate with an organization. It's no harm. I would ask that they be included, but if the board doesn't, we will accommodate your request.
It would simply be a matter of Mr. Allen keeping a list of who's been authorized by him, since he's the responsible party and he's the interested party, correct? Am I correct that a county then, if they would have to go back to Mr. Allen to say, is this individual on the list?
So in a recount that takes multiple days, there may be several different people from an organization taking turns.
How about this, in terms of Mr. Allen's name is affixed to a sheet that has the Election Integrity Fund in force? That is the group that we provide as the interested party.
That makes sense.
That makes sense.
Thank you,
sir.
Mr. Brader, does that work for you?
Yep, as long as we have a motion to enforce.
Do we want to proceed with dealing with the attached procedures? Get that out of the way.
I think we should do that
Okay.
first because if we don't approve
If we don't, what's the point?
Okay. Yep. You want me to make that motion?
If you are so inclined.
I would be so inclined. I move that the board adopt the attached procedures recommended by the Bureau of Elections for the recounts of Proposal 2022-2 and 2022-3.
I second.
We have a motion and a second. Do we have discussion? All those in favor signify by saying aye.
Aye.
Aye. Any opposed? That motion carries 3-0. Now we have the issue of interested parties. And again, forgive us as we get this straight. We want to do this correctly. There are two separate proposals at issue here. We have multiple groups. We have just, through discussion here, determined that the interested party from the standpoint of opponents to these proposals will be the, let me get it right, Election Integrity Fund and Force, and that they will be interested party for proposals 2022-2 and proposal 2022-3. Obviously, somebody can make a motion to that effect. Should we add them all at the same time, or is it okay if we do that and then do the others?
I think the cleanest thing to do would be to say electionary force, promote the vote in Michigan Democratic Party with regard to proposals 2022 and 2022. Those are the ones that are sought for vote.
Okay.
Want Mary Ellen to do that one?
Sure. Did you listen to what he said?
Wait,
It was.
we're talking just about two?
So the ones that want to be interested parties for both proposals 2 and 3 are Election Integrity Fund and Force, Promote the Vote, and Michigan Democratic Party.
And that's for both?
Correct.
And just for?
And for 2 only is Promote the Vote.
For 2 only.
And for 3 only is Reproductive Freedom for All.
Okay.
Good luck.
So I move that the following groups or individuals are considered interested parties for the purpose of acting as challengers in the recount of proposal 2022-3, election integrity and force. Wait.
You forgot two.
Wait, no. Sorry, there's one. I'm sorry. We're going to propose one motion that will cover both 2 and 3, then one motion that will only cover 2, then one motion that will only cover 3. If that makes sense. Okay. Just to save time. So you have to
You're
read
really
all.
challenging me.
I'm sorry. I'm trying to make you not read the same names multiple times.
Okay, so the one that covers both 2020, okay, so that I move that,
This one right here. And
that for both proposals 2022 and -2 and 2022-3, we recognize as interested parties election integrity and force, promote the vote, and the Michigan Democratic Party. I got that?
we have a motion and support. Any discussion? Seeing none, all those in favor of the motion signify by saying aye. Aye. Any opposed? The motion carries 3-0. I'll entertain a motion for the next piece.
Okay. I move that the following groups are considered interested parties for the purpose of acting as challengers in the recount of proposal 2022-2. Promote the vote 2020-22.
Just promote the vote 2022.
No, it's, no.
Because we already did them.
Okay, promote the vote 2022 and election integrity and force.
Don't need that one either because we did that in the
Okay,
previous one.
we did that for both. Okay, I'm sorry.
That's okay. So just
Maybe instead of this, maybe we should have Mr. Hauskamp doing it.
Okay, I sent it to you for exactly that reason.
Okay.
The only one we need for proposal 2 is just promote the vote 2022.
Okay, and that's, okay. So I recommend, or I move that promote the vote 2022 be recognized as an interested party for the purpose of acting as a challenger in the recount of proposal 2022-2. Okay, I've got it. Okay.
We have motion and second. Any discussion? Seeing none. All those in favor signify by saying aye. Aye. Any opposed? Motion carries 3-0. And
I also move that the authorized representatives may limit the number of, that the Board of State Canvassers may limit the number of challengers able to observe each precinct at any one time to one challenger in support of the proposition and one challenger opposed to the proposition as necessary to conduct an orderly recount.
I second that motion.
we have a motion and a second. Any discussion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries 3-0, and we need one more motion for proposal 3, and that is just for reproductive freedom for all to be an interested party. And so I will entertain a motion for that.
I move that the following groups or individuals are considered interested parties for the purpose of acting as challengers to the recount of proposal 2022-3 and its reproductive freedom for all.
Do we have a second?
Second.
We have a second. We have a motion. We have a second. Do we have a discussion? All those in favor signify by saying aye. Aye. Any opposed? Motion carries 3-0. According to my notes on the agenda.
I think we still need to resolve an issue that was raised by Mr. Liedl about whether the petition for a recount for proposal 3 requests, correctly requests recounts of the in-person precincts in the city of Detroit. I believe it doesn't. The absentee counting boards are spelled out. in the petition. From number 419 to number 519, no, 515, I'm sorry. So the absentee counting boards are, a recount of those is specifically requested in the petition. There is no specific request for a recount of the precincts in Detroit that are not in the absentee counting boards, and I think we need clarification that the in-person precincts in Detroit would not be subject to recount.
Director Brader, I'm not trying to stifle anything on this. I would think that based on the motions we've made, we've put that to bed, but I'm seeking your thoughts or council's thoughts on that in how best to address this.
My assumption was the motion that we put for the board's consideration was to recount the petition as presented, but I do acknowledge that this issue has been raised. So the Attorney General's office think this needs to be clarified based on the motions made. There might be a lawsuit either way, I don't know.
Might.
Well, the statute requires that the petition be sworn, right? So the handwritten language at the bottom of the petition was not language that was sworn by the proponent, by the petitioner, because it was added by Ms. Lambert when she came before the Bureau of Elections, right? So arguably, it was language added to the petition after it had already been sworn. So there's a question as to whether it's really part of the sworn petition.
So it's essentially like changing something up after you've had a document notarized. Like you can't do that. You can't, oh, sign this and then I'll fill it out later.
Right, you signed it and then somebody added something afterward.
So when that was signed, that was the end of it right there.
It might have been different if it was Mr. Allen's signature, like if Mr. Allen had written it himself, but then it was written by a different person after it was sworn.
We are 15 minutes past when we've been designated to leave. Mr. Hartman, 2 minutes.
Thank you for the recognition. That language was added at the time the Bureau of Election staff, without the people that were there, determined that those had to be added in order to be able to do the recount. It was not part of the original petition. Ms. Lambert added it at the time. As I understand this is secondhand information, but it was not contemplated by Mr. Allen, if that helps your vote. In full transparency, it was believed by the people that were advising Ms. Lambert at the time she was filing it that that was required in order to file it. So she added the language. She added those additional people, and they paid a deposit on that.
Thank you.
So what Mr. Hartman has just said is that this was not from Mr. Allen, but it was from Ms. Lambert, who had not sworn to the petition. And so I think it's clear that and you just look at the petition, which lists very specifically the absentee county boards in Detroit, but not the precincts. So this is not an insignificant matter. We're talking about
I agree.
more than 500 precincts in Detroit and a substantial burden put on Wayne County and on the city of Detroit, and that was not called for in the petition, and we should not authorize it.
Sorry.
I guess I would just ask, I know that it's tough and we're over time, but if we could just get the board's understanding and emotion either way, whether this includes the in-person precincts or does not, then we can go with that.
Yeah. Thank you. I'll entertain a motion if you wish.
Okay, I move that our authorization of the recount on Proposal 3 be clarified to state that it does not include a recount of the in-person precincts in the city of Detroit.
I'll second that.
motion and support discussion, one piece of discussion from me is that proper that it's just for 3, or should it be for both of them?
It was only requested for 3.
Thank you.
Yeah.
Okay. All right, we have motion, support, discussion. Any more?
Just one question, just to confirm. Mr. Hartman, you're saying that your client did not put that in originally and it was put in by Ms. Lambert at some future point? That's a yes or no question?
Yes, at the request of the Bureau of Elections.
Okay. All right, all those in favor of the motion signify by saying aye.
Aye.
Aye. Any opposed? Motion carries 3-0. With that, we are adjourned.
Do I need a motion for that?
Nope. Oh. Norm never asked for one.